Next, from Chicago and the mid-year meeting of the Illinois Bar Association, members of the Illinois Bar hear a keynote speaker discuss juvenile justice and what role the courts may take to help rehabilitate juvenile offenders. This runs about 45 minutes.
I want to thank you personally, all of you, for being here today. We have a subject of tremendously great importance to discuss. It's important to all of us, the lawyers and judges in Illinois, and to the public we serve. You know, every generation is faced with the task of safeguarding the well-being of the next generation. You know, as parents, we nurture our children from when they're born to adulthood and beyond. And as grown-ups in the community, we set an example we hope young people will grow up to follow. And as lawyers and judges, we have a special duty to those young people who are having a difficult time growing up and find themselves in trouble with the law. Here in Cook County, there's been a court dealing with juvenile matters since 1899. It was the first such court in the country. One of the first judges of the juvenile court, Julian Mack, framed the court's mission this way, quote, "The problem for determination by the judge is not, has this boy or girl committed a specific wrong, but what is he? How has he become what he is? And what had best be done in his interest and in the interest of the state to save him from a downward career?" End quote. Our program this morning consists of a keynote address and a panel presentation. Our presenters are knowledgeable professionals who have taken on the weighty responsibility of attempting to change the direction of young offenders' lives. A seemingly impossible task. They've had successes, but they've also had and experienced failures. More than most of us, they know what works and what does not work. Now I'd like to introduce you to Judge Michael Corriero, our keynote speaker on the topic, Judging Children as Children, which also is the name of a book he's written and subtitled, A Proposal for a Juvenile Justice System. Judge Corriero comes to us with an amazing biography. He is the founder and director of New York Center for Juvenile Justice. He served many years as a judge in the New York State courts, including 16 years presiding over Manhattan's youth court, dealing with youth being tried as adults. You'll be hearing some inspirational recollections from Judge Corriero on his experiences there. In 2008, Judge Corriero retired from the bench, spent 2 years as executive director of the Big Brothers Big Sisters of New York City before founding the New York Center for Juvenile Justice. The center seeks to establish a comprehensive model that will treat children as children and develop strategies designed to improve their chances of becoming constructive members of society. He has served as chair of the Committee on Juvenile Justice of the Association of the Bar of the City of New York and currently co-chairs the American Bar Association's Committee on Children and the Law. Without further ado, please join me in welcoming Judge Corriero to the podium. Thank you very much.
Good morning, everybody. Thank you for inviting me. Oh, I'm supposed to do some little housekeeping. I'm not Mark. Good morning, everybody, and thank you for inviting me to this beautiful city. When I got in late last night, I didn't have a chance to look out the window. When I looked this morning, I saw the beautiful lake and the sun rising over, and I said, it's going to be a great day, especially because I was quite frightened of the snow last night that I'd never be able to get home. But it's really wonderful to be at the birthplace of the juvenile court. And for me, this has a special significance. As Mark pointed out, I was a judge for 28 years in the New York City, New York State criminal courts. The last 16 years, I presided over a special court which we came to call the youth part. In actuality, it was an adult Supreme Court part. Now, New Yorkers are pretentious. The Supreme Court is not the Supreme Court in New York. It's not an appellate court, but it is the court of a felony trial jurisdiction. And I sat in that court and saw all of these young people coming into the court and being randomly assigned to 50 or so of the judges who were sitting in the criminal term. And I thought we could do a better job in dealing with these young people by putting their cases before one judge, where we could have one courtroom, one place for all of the programs that wanted to deal with children, all of the social workers that wanted to come and try to lobby judges to give them children to work with in one place before one judge, and that there would be some consistency in the way in which we dealt with children. In order to understand the significance of the youth part and my experiences in presiding over that court, you need to know a little bit about the legal context in which New York functions with respect to children. Prior to 1978, the cases of all children under 16 years of age who committed an offense, regardless of the severity of the offense, were prosecuted exclusively in New York's family juvenile court. We call our juvenile court the family court. Juvenile delinquency proceedings are part of the family court proceedings. So prior to 1978, the cases of all children under 16 years of age, regardless of the severity of the crime with which they were charged, including, for example, murder, were prosecuted exclusively in the juvenile court, where they faced placement for no more than 5 years or until they reached the age of 21. This proved to be a mistake. New York should have had a safety valve written into the law that would have permitted the judges of the juvenile court to transfer out of the juvenile court the cases of those children whose crimes and backgrounds indicated that they were a significant danger to the community. Because in 1978, along came a young boy by the name of Willie Bosket, who murdered 2 people on the subway before he reached the age of 16. And when the public, through the media, became aware, now wait a minute, Willie Bosket is going to the juvenile court where he's going to be placed for no more than 5 years or until he reached the age of 21? This is scandalous. How are we dealing with young people who are capable of such violence? 1978 coincided with a gubernatorial election. The incumbent governor, who was considered very progressive, very thoughtful and sensitive about these issues, was running against a very tough law and order candidate. And neither of them wanted to appear weak on crime. So we revisited in 1978 the way in which we dealt with young people in New York. And instead of adopting the predominant mode of dealing with young offenders, which was to develop a transfer-up or a waiver-up system, New York instead in 1978 took the cases of children as young as 13 who were accused of murder, and the cases of children as young as 14 who were accused of robbery, assault, kidnapping, the most serious crimes under our penal law, and we reclassified those crimes as juvenile offender offenses. And so if you were 13 and accused of murder, or 14 and accused of one of these classified juvenile offender offenses, your case was to be automatically prosecuted in the adult court, where you would face mandatory imprisonment of a minimum of 1 to 3 years, for example, for robbery in the first degree, with a maximum of 3 1/3 to 10 years, and upon conviction for that offense, you would incur a felony record. And the only way out from under the automatic prosecution of children as young as 13 in the adult court would be for a judge to exercise his or her discretion in granting what we called youthful offender treatment, which means that after a conviction, the judge can substitute for that conviction a youthful offender adjudication, which has the effect of sealing the record and frees the judge up to give an alternative sentence of probation, a non-incarceratory sentence. But the exercise of that discretion was carefully circumscribed by the juvenile offender law, which carried a presumptive punitive response to the to the violations of law by these young offenders. And youthful offender treatment, if the judge decided to grant it, was appealable by the prosecutor. So the courts had, for the first time in over 75 years, to deal with children as young as 13 who were accused of these serious offenses. Now, New York already had a very low threshold of criminal responsibility. 16 is the age of criminal responsibility in New York, and that is the current age of criminal responsibility. So if you're 16 and you steal a hubcap in New York, you're going to be in the adult court, and again, you're going to face criminalization. So in 1992, we decided that there has to be a better way of dealing with these young people, and we created the Youth Part to try and address the special issues that these young people presented to the adult court. Because when the legislature delivered these children to the adult court, and that's essentially what they did, they just delivered their bodies to the doorstep of the adult courthouse, they gave us nothing else. No additional resources, no additional probation services, no programming specially designed for these 13, 14, and 15-year-old kids. So the best way that I can explain what I tried to do in the youth part is by reference to a film. I don't know how many of you ever saw the movie A Bronx Tale, but it was a pretty popular movie. Bobby De Niro was in it, Chaz Palminteri. The movie was about a young boy growing up in the Bronx, New York during the late 50s, early 60s. And his nickname is C. And there's a pivotal scene in the movie when this young boy is walking through the streets of his neighborhood when a car packed full of his friends pulls up to the curb. Hey, C, come on. Get in the car. He squeezes into the back seat of the car, friend on each side. He looks down at his feet, and he sees a box of Molotov cocktails. His friend in the front seat brandishes a gun. And in the movie, we hear C talking to himself. I don't want to be here. I don't want to do this. This is wrong. But he knows he can't tell his friends, hey guys, stop the car, let me out. I don't want any part of this. Why? Because he feels he'll lose face. He'll lose respect. He'll lose their friendship. And just when all seems lost for C, who's in turmoil, the car is cut off by the other protagonist in the movie, Sonny, a local wise guy, a gangster, who took a paternal interest in C. And Sonny reaches into the car and pulls C out of the car. And his friends drive on to tragedy. I won't spoil the movie for those of you who haven't seen it yet. But I like to think that what we tried to do in the youth part was to metaphorically reach into that car and pull the kids like C out of the car. The kids who were in turmoil because of peer pressure, couldn't get themselves out of a situation that perhaps they didn't initiate or fully embrace, yet they didn't have the maturity and sense of self-confidence to say, stop, let me out. I don't want any part of this. Now, the prosecutors thought there were less of those kids in the car than I did. Defense attorneys thought there were more of them. And the social workers wanted everybody out of the car. And I had to strike the balance. I had to decide who went to jail, who didn't, who got a felony record, and who got a second chance. This is an awesome responsibility. As those of you who practice in this field know, that the decisions we make with respect to young people can affect their entire lives. Decisions that we often make on very little information and often on the basis of instinctive experience. How many of you have ever been 14? How would you like to be defined forever by what you did at 14? And that's the real tragedy of laws that do not view children as children, but require their prosecution as adults. It changes the lens by which we view their behavior. And it permits us to impose sentences that would ordinarily be quite shocking if we were to think of them in other terms, in terms of dealing with our own children. There was this wonderful, I'd like to talk to you about some of the kids who appeared before me and how we dealt with their cases. But before I do that, how many of you ever saw the old TV program, The Wonder Years? This is a show and tell. It's early in the morning. So you got to help me, because we were out last night at Kiki's Bistro, and your president gave me a lot of champagne that I could not handle. So I need your help this morning. It was a great restaurant, great choice. How many of you ever saw the Wonder Years? Okay, good. Now, of course, the Wonder Years, I got attracted to because I liked the music. It was the music of the 60s was always the background. But I only caught one episode, and the episode that I caught was quite intriguing to me because the young boy Kevin, and the format of the TV program is that this young boy Kevin is going through his childhood experiences, and the older Kevin, is kind of overlaying, and at the end of each show would essentially give a moral to the tale that we were watching. So in one episode that I saw, Kevin had a crush on who? Huh? Who said that? Winnie Cooper, right. Now, Kevin had this crush on Winnie Cooper in the episode that I saw, but he never followed through on it. He never asked her out. Why? Because his friends didn't think that Winnie was very attractive at the time. She was very studious, and the kind of girl that the boys liked. Of course, she grew up to be very beautiful, very powerful, and very successful. But at the time, she was kind of an awkward teenager. Kevin liked her, but he never followed through it. And so at the end of this particular episode, the older Kevin is looking back and lamenting, regretting the fact, I liked her, but I never followed through on it. And then he said, but who are you at 14? Who are you at 14? You are what your friends think you are. And I said, wow, what an incredible insight into the nature of adolescence. That very often, as teenagers, our view of ourselves does not come from within, it comes from without. That we are the mirror image of what our friends think we are. And that reality is one of the major causes of juvenile crime. Rarely did I see a single 14-year-old robber. It was usually the group context that was motivation for the crime. Not necessarily that he needs that jacket, but what are my friends going to think of me unless I'm down with them in this situation? And that's why the youth part was important, because we wanted to be able to have the flexibility to channel out of the system those kids that we thought we could work with, those kids that we thought we could prevent from incurring the indelible stigma of a felony record for the rest of their lives. Let me give you, Judge Timberlake knows some of these examples, but there's an old lawyer that we know each other since we first got out of law school, Howard Jaffe. And in the youth part, every Friday we'd have a calendar day, so all of these kids would be coming in. I'd be monitoring their cases, supervising them, very much like the problem-solving courts. But also, I'd be seeing new cases coming in. And Howard Jaffe came in, and he's a lawyer. We know each other a long time. We tried our first case against each other. I, as a young prosecutor in the Manhattan DA's office, and he as a young legal aid defense lawyer. And we'd always joke with each other, because it was so long ago that we both remember winning. And we were challenging. I won that case. No, I won that case. But neither of us have had the courage to go look and see whose mind has deteriorated quicker than the others. But anyway, Howard came in and he had this young boy with him. And one of the things that I always tried to do was try to find out always talked to the young people that came in. I never asked them about the nature of the case or their involvement, but I wanted to know what schools they went to. What did they like in school? Did they like to read? What was the last book that they read? And they knew that I was, and Howard knew because he had practiced with it, that every once in a while we had a youth part library. If I thought a kid had the potential, I'd give him a book. I loved Dickens. And he said, Judge, he said, I want you to know that my client is reading. He likes to read. I said, well, what is he reading? He said, he's reading A Tale of Two Cities. I said, is that right? So I looked up, I said, you're reading A Tale of Two Cities. What about it? He said, I like it. I said, well, what did you think of it? Was the best of times? It was the worst of times? And then he paused and he looked at me and he said, I didn't get that far. True story. I said, Howard, I said, you're in trouble with me. Another young boy comes out, 14, handcuffed behind him because he's being prosecuted as an adult. And so when they gave us these kids, they didn't give us these beautiful juvenile facilities, you know. We just converted the adult, and they're called holding pens, to accommodate kids. There's still bars. They still have to go to the bathroom in front of their peers. So this kid comes out and he's got handcuffs behind his back. And I say, you take the handcuffs off him, because nobody comes into my courtroom with handcuffs on or shackles. Not 14-year-olds and not 15-year-olds. You take them off. So he took them off. The court officer took them off. And then I see this kid had something in his hand. I said, what is that in your hand? He said, a book. I said, what is it? The Bible. I said, the Bible. I said, what are you doing with the Bible? He said, I'm reading it. I said, you're reading it. So his lawyer's looking at me now. I said, what are you reading? He said, the book of Genesis. The book of Genesis? I said, what did you learn by reading the book of Genesis? So he was a colloquy between him and his lawyer. Then he looked at me and he said, well, he said that God loves us so much, he gives us the freedom to make mistakes. What a shrewd little boy this was. Well, of course, I sit in New York, in God we trust. I said, well, I'm not God. And you got to pay for what you did here. You got to be held accountable. But that is the essence of what we're talking about, this idea of free will and the exercise of it. And to what degree are we going to penalize and hold culpable children for their poor choices at 14 and 15 years of age? Little girl, 14-year-old African-American girl, riding on the subway with her girlfriend, who's a little bigger than she is, a little tougher. And they're sitting across from another group of young women, also on their way to school. And the girl that's with, we'll call this 14-year-old girl Loretta. The girl that's with Loretta says to Loretta, look at those earrings. And there was this one young woman sitting over, and she had these, what do you call these big things? The hoop earrings. Are your ears pierced? Yeah. Well, this little girl had pierced ears and these big hoop earrings on them, and they were apparently very nice. And the bully that was with Loretta said, Loretta, I like those earrings. I want them. And the bully got up, and Loretta got up with her, and the bully hovered over this little girl and said, give me your earrings. The girl tried to ignore it. Give me your earrings. The girl got up, tried to walk away, but was blocked by Loretta, who was standing next to the bully. So she sat back down. Again, the bully demanded the earrings. Again, the girl tried to ignore her. This train started to slow down to enter our 14th Street subway station. And as it did, the bully again demanded the earrings. Again, no response. And the bully reached down and ripped the earrings out of her ears. The doors opened up, and there happened to be a police officer at the doors, immediately sized up the situation, arrested both the bully and Loretta. The bully still had the earrings in her hand. The girl was screaming, blood dripping from her ears. Charged Loretta and the bully the crime of robbery in the first degree. Loretta was charged as an accomplice, faced mandatory imprisonment of a minimum of 1 to 3 years, maximum of 2 1/3 to 7 years, and upon conviction, a felony record. Loretta comes before me, and she's being held in on bail because one of the oxymorons about trying children as adults is bail was set. And bail was set at $500. Now, how many 14-year-olds have piggy banks with $500 in it to bail themselves out? So she wasn't able to make bail, and it took about 30 days for the case to process itself through the lower courts to get to me, because I only had all of the cases that were indicted. And so she comes out, and I find out that she's never been in trouble before. that she's going to one of our schools for the performing arts, that she's a very talented young dancer. So I tell one of the program representatives who essentially came to me to lobby me for kids to interview Loretta. Tell me what you think of this little girl. Program representative came back a few days later and said, you know, Judge Corriero, I spoke to Loretta and I asked her a typical social worker question to get a sense of who she was, what her relationships in the community were. He said, I asked Loretta, if you could change 3 things in your life, what would you change? She said, Judge, you know what she said? I said, no, what did she say? She said, Loretta said that she would change her country, she would change her family, and she would change her sex. Her country, because she believed that America was a racist society. Her family, because her mother was a crack addict and she never knew who her father was. And her sex, because she felt that young women were vulnerable to physical and sexual abuse. How do you deal with Loretta? How do you say, Loretta, don't you realize around your talent, you have the power, the capacity to change the circumstances of your life? How do you get her to believe that? How do you get it to believe, for lack of a better term, in the American dream? The idea that through education, you can improve your talents, discover your talent, and achieve all the potential that lies ahead of you. How do you get a 14-year-old like Loretta, who's experienced what she's already experienced, to believe? Because what is it that keeps kids, what is it that would have kept Loretta from getting up with the bully? I'm saying, hey, I don't want to get involved with you. I might jeopardize my career, my schooling. Because I believe the stronger you believe in the dream of your destiny, the more likely you are to be able to resist negative peer pressure. Now, I grew up Mulberry Street, Little Italy, very much like C in A Bronx Tale. My father was born in America, but went back to Italy with his father until he was 14, sent to America with 2 of his younger brothers. My father was one of 7. My mother was one of 7. That's why I'm an only child. My mother was one of 7. Her father, unfortunately, died when she was 14, and she was the oldest, so she dropped out of school. When my father came here back from Italy, he didn't speak a word of English. They wanted to put him in the 5th grade or 6th grade. He was embarrassed. He never went back to school. He eventually got a job. He was over 30 when he became a longshoreman. My mother was a seamstress in a sweatshop on Lower Broadway. We lived in a tenement, literally in the shadow of the criminal courts building, the Tombs, as we called it, a 3-room apartment. My next door neighbor was this young boy, we used to call him Eddie Boy. Well, Eddie Boy was born about 6'5". He was feared by everybody in the neighborhood, and I was always skinny. You know, you walk down the street, everybody wanted to fight Mikey, you know, because I was always very skinny, always very weak and physically in that sense. But Eddie Boy loved me, and he protected me. And when I walked down the street with Eddie Boy, I was tough, and nobody messed with me. And I often wonder, like Loretta, you know, the bully was her friend. Yet in one generation, through education, because my parents believed in the power of education, they sent me as early as they could to Chinatown, where there was a Maryknoll missionary school. The Maryknoll missionaries educated me. They insisted that I go to a parochial high school where I met the Irish Christian brothers, who had an interesting way of disciplining you. Still feel the pangs of the leather straps and whatever. And they insisted that I go to a parochial college. And I found the only co-ed parochial college that existed in New York at the time. It was for St. John's, to their chagrin. But through education, in one generation, we went from that 3-room tenement to a judge. That's the American dream. And that's what we are, in effect, denying so many children for their poor choices who are coming from difficult environments. I was thinking of Loretta's case one day when a group of these terrific, well-dressed young women from a high school in one of our wealthy suburbs outside of New York came to watch, because I always opened up the court. I wanted people to see what we were doing. I wanted them to see the kids. I wanted them to hear them. Because very often the public and the community, in their mind's eye, they think of these kids as some kind of demonic incarnations when they are far from that. And so I wanted people to see the young people whenever I could. So teachers would bring their kids, and there'd be contemporaries, the 14 and 15-year-olds, and they'd see these kids coming out and going to jail or getting connected to a program or what have you. There was these group of young women, very bright, very bright. I said to them, how many of you believe in the American dream? And one bright little young girl said, wait a minute, what do you mean, Judge Corriero, by the American dream? I said that in America, no matter who you are or where you come from, you have an equal opportunity to succeed. They said, how many of you believe that? Let me see a show of hands. And not one hand went up. And if these young people coming from such a wealthy suburban community where they had all that our society can offer felt so disillusioned, how much more so is that disillusionment, that alienation in a child like Loretta, who is essentially an orphan and has no positive supports in their lives? 6-year-old girl answers the knock on the door to her apartment. It's her father who's estranged from her mother. Go get your mother, he says to the girl. The girl goes into the kitchen. Mommy, Daddy's at the door. 7-year-old girl, I think she was 7. She goes to the front of the door. The mother goes to the front of the door. The little girl is standing behind her. Father takes a can of gasoline he was hiding, douses the mother from head to toe with the can of gasoline, lights her on fire. The mother is horribly, horribly burned, disfigured, but survives. 8 years later, this little girl's in front of me for putting a gun to somebody's head and saying, give me your money or I'll blow your brains out. And who comes to lobby me for this young girl? But the very prosecutor who prosecuted her father for attempting to murder her mother and remembered this little girl in his office because he was interviewing her to find out about the facts of the case. And he remembered telling the mother, you've got to get help for this little girl. She feels responsible. She asked you to go to the door. She really needs help. And the mother, overcome with her own issues, of course, never got the kind of help that would have helped this young girl to deal with such a horrible, horrible incident. And now she's before me. So how many years do I put her in jail for? What is the extent of her culpability? Do we forever define her by this act? 6-year-old girl comes in. And Judge Timberlake knows this. If I raise my voice, my wife said to me, you sound angry. And I said, no. I said, I'm not angry. I'm Italian. So I'm not angry. But I am passionate. And I believe that we have an obligation to change the way children are treated in our courts. So, 6-year-old girl walking down the street again, holding her mother's hand. Father crosses the street, accuses the mother of having an affair with his best friend. Takes out a switch knife, slashes the mother across the face, stabs her in the heart. Mother falls to the ground, clutching the little girl's hand. 8 years later, this little girl's in front of me for slashing the face of a rival girlfriend over a boy. How do we deal with this little girl? What are the odds that we're going to have the mental health capacity to undo the damage to this young girl? And when you think of it, the answer is we don't have any mental health responsiveness, although you in Illinois do. As I was reading, you do have a special project to try and identify early on as many young people as you can that are suffering from mental health issues that you can address, and it's so important. But in reality, most places where children are being tried as adults, these kind of programmatic options are unavailable because they're being viewed as adults, not as children. And so we have to change the lens by which we view these children and bring the options that are available in family courts and juvenile courts into the adult court to deal with 16 and 17-year-olds. Why? Because let's say that I gave every 14-year-old kid who committed the crime of robbery in the first degree the maximum sentence that the law permitted under the JO, 3 1/3 to 10 years. I might get elected governor. But let's say I gave them all the maximum. They would all be back in the community before they're 21 years of age when you do the math. If they stay out of trouble, they get out at the end of the minimum, then they go on parole or for the remainder of their time. So if you do the math, most of them are back before they're 21 years of age. So when you talk about what is how should we approach punishment for 14, 15, and 16, 17-year-olds, several ideas have come to my mind and have infused the way in which I've responded to many of these young people. First was the story of the unruly child. A teacher herded an unruly child into the principal's office and started telling the principal, you know, this kid is terrible, you know, I can't control him, he writes on the board, he disrupts the class. Wait a minute, the principal, wait a minute, he's only a child. You have to treat him with patience, love, and understanding. And just then the kid picked up the principal's inkwell and threw it against the wall, splattered. The principal grabbed the kid, threw him over his knees, spanked him. The kid was screaming, howling for mercy. The teacher said, wait a minute, you just told me he's only a kid. I have to treat him with patience, love, and understanding. And the principal said, oh yes, you do. But first, you have to get their attention. And that's true. When a kid come in, I want to get his or her attention. I want them to know that this is serious business, that at the end of the road here could be jail, and that the community expects a certain amount of accountability for their behavior. And I have a responsibility to protect the community from violent and dangerous children. So I want them to know this is serious. And I can be tough with them in the beginning, and then I can be who I really am as time goes on, depending upon their progress. And then there's the poem by Elizabeth Browning. A redhead child, sick in fever. If you touch him once, though but so little as with a fingertip, will set you weeping. But a million sick, you could as soon weep for the rule of 3 or compound fractions. In other words, if the subject is abstract or distant or remote, it doesn't have that empathetic response. But we cannot ever lose our innate compassion for children, our innate instincts with respect to children. I just saw the other day, these kids, must have been about 20 of them, little 6-year-old kids. They were all connected to like now the teacher. On one end, the teacher had like a little handle, and on the other end, the other teacher had a handle, and they were all tied to it. They were like little caterpillars. You know, they were all, and your instinct with respect to these kids is, you know, to nurture them. This is a powerful instinct. And yet, very much like prohibition, we're treating children as adults. Cicero said that true law is right reason in agreement with nature. Well, treating children as adults is not right reason in agreement with nature. And it is an approach that goes counter to our instincts. Horace Mann was invited to speak at the dedication of a reformatory. And his thesis was that all the money spent on this reformatory would be worth it if only one kid was saved. And one of the people in the audience said, wait, you've got to be exaggerating. What do you mean all the money spent for this reformatory would be worth it if only one kid was saved? And Horace Mann's response was brief but eloquent. He said, yes, it would be, if it were my child. And that's the standard. And where does that standard essentially come from? It comes from you, Cook County, 1900, the first annual report of the Cook County Juvenile Court. Treat children as a loving and just parent, or caring and just parent. What is it? You should know it, right? It's yours. It's yours. It's the overarching sentiment that was at the basis of the creation of the juvenile court, the idea that we were going to treat children differently. What does it mean to judge children as children? It means that we should recognize their developmental differences. We should recognize the nature of adolescence. We should have responses that address the special needs programmatically. And when we sentence them and deal with them, we should leave room to reform. We should not indelibly define them because they are malleable, because they're growing, they're not yet mature. I got where's Melinda? Because you're my timekeeper, right? You cut me off. I got an email. What does that mean? I have 3 minutes? Oh my God. All right, so wait a minute. I'll have to tell that other story later. But what I want to tell you is what would the system look like that would enable children to be tried as adults? So there'll be 4 objectives. Number 1, you want a system that precisely identifies the violent, dangerous, and chronic juvenile offenders. And what kind of a system is that? That is a transfer-up system. And what should be the age of criminal responsibility? 18. And who should have the responsibility of deciding which cases go to the family court? Not the prosecutors. That's kind of one-sided. Legislature, because it's too remote. It should be the judges of the juvenile court, the family court. That means you have to revitalize your juvenile court, your family court. You have to get more judges. You have to do what you need to do in order to make it a viable institution, but that's where the responsibility should rely. 2, you need to have flexibility in your dispositions. You need to have sufficient programmatic flexibility so that you can react appropriately to the needs of the children that are appearing before you. 3rd, you need to have a system of sentencing that is primarily designed around educating young people. When we educate our children, we don't do it out of retribution. We do it for the purpose of socializing them, for educating them. And that is the idea behind any institution that we should be sending children to, that institution should be given the responsibility of making sure that when a child comes out of that institution, they are prepared to meet the challenges ahead of them in a constructive way. Anything less is unsatisfactory. And 4th, there should be a system of decriminalizing the young people who commit acts that society at the particular time in which they were committed is incapable of excusing in terms of defining them as serious infractions on the rest of the community. But that doesn't mean it should end there. You got a 14-year-old, I got an email from, I can't tell the story, but a 14-year-old boy comes out of an institution, gets married, wants to drive a taxi in New York City. He can't do it because he has a felony record. So we should have a system where after a sufficient period of time of law-abiding behavior, a child can come back into court and have that youthful conviction completely expunged to the extent that it will not carry any impediments to future employment. So if we can do that, if we can set up a system where it will be a transfer-up system, integrate into it a system of decriminalization, I think we will have gone a long way to enabling the judges and the courts to deal more appropriately with children. And in the final analysis, I view trying children as a matter of due process. And the late Supreme Court Justice William Brennan said it best. He said, if due process values are to be preserved in the bureaucratic state of the late 20th century, it may be essential that officials possess passion, the passion that puts them in touch with the dreams and disappointments of those with whom they deal, the passion that understands the pulse of life beneath the official version of events. Thank you for letting me share my passion with you.
You're watching the Illinois Channel, an independent nonprofit corporation formed to provide gavel-to-gavel coverage of Illinois state government and other public affairs events taking place across Illinois.